Hello everyone, welcome back. Just a quick note, while we are in Module 5, I really do encourage my viewers to really go back and watch Module 1 to 4 before jumping into 5. There's a reason that they are in sequence because they literally break down the foundation of why risk assessment is important and how you can approach it with caution, of course, but essentially what I also like you to do is understand the dynamics of the different sections that actually align to discuss the gaps that are in place. Now, Module 5 addresses what the empirical literature on AI governance consistently identifies as the most consequential proximal failure point in organizations, specifically with focus on AI management. Not the inadequacy of governance framework specifically, but the systemic failure to really communicate the implications in ways that produces institutional action or lack of. Now, the IAPP AI Governance Professional Body of Knowledge version 2.5 identifies the capacity to create and deliver structured awareness programs across all organizational stakeholder categories, including non-specialist leadership, as a testable professional competency under domain IB. Now, the module that we're going to be discussing today is going to look at the operationalize of the competency. It does not describe communication as a supplementary skill. It establishes more of the governance communication as a core professional obligation. And of course, what that means is this is a co-equal in significance where risk identification and protocol development must be adhered to. There are 6 lessons, 6 usable instruments. By the time we reach lesson 5.6, you will have to have produced the first 2 sections of a broad, ready AI risk briefing document grounded in forensic documentation standard. Now, I say documentation standard forensic aspect because the way I look at it is you're responding to this. If there were legal implications, you want to have documentation that can actually stand against expert testimony or journal articles. So if you do your due diligence while bringing this document into life, this briefing, you're also substantiating your finding. Now, we've talked a lot about the NEST AI Risk Management Framework, RMF, and the current regulatory architecture of the European Union's AI Act. I talk about it a lot, and it is very imperative that we fully understand why it's important and how we can proceed in that level. So, the outcome, as promised, is 6 deliverables. The pedagogical premises this module is that the governance and knowledge which cannot be communicated to decision-making authorities. But I also want to understand, for practical purposes, non-operative reasons, the 6 instruments will help you resolve a problem. A diagnostic taxonomy of communication failure models, enabling practitioners or operational staff or administrative staff to identify, then remediate the specific deficiencies that render AI governance briefing ineffective at the board level. The forensic reporting methodology that was discussed in Module 2 is derived from the evidentiary standard in clinical and legal practices, and this adapts to produce AI risk documentation that withstands regulatory scrutiny. An original persuasion of framework, I would talk about the AIARE model, or as I call it, AIARE model, grounded in behavioral science, and the OPS impact and the influence competency. These are terminological translations where when we're talking about architectural mapping and regulatory language to organizational equivalency without sacrificing definition or precision. And the repertoire of the scripted responses to the 6 more relevant form of board resistant to governance investment, and the 7-section board briefing templates that integrate the analytical output of AI models 2 through 4 into a single defensible communication document. So each of these instruments are deployed in your next board interactions. The idea here is to understand the standards against which the module should be evaluated against. So why board level communications fail? Here's the key question. If you cannot explain your organization's bigger AI risk instruments and without jargon, can you actually govern it? Right? So how are we looking at those factors? The question on the slide is not rhetorical, it is a diagnostic instrument. If you cannot articulate your organization's most consequential AI risk in 2 sentences without recourse to technical non-nomenclature regulatory acronyms or abstract risk categories, you have not yet completed the governance analysis. So communication precision is not a presentation skills appended to substantiate work. It is the forensic epistemology of discourse that has consistently maintained the evidentiary standard to which governance finds must be held. You might think not everything is forensics. We have a lot of white collar crime now, even more evident, and we've seen them hack some of the largest organizations. The most recent one I've discussed in the last couple of modules is the infrastructure of a learning management system, also known as operative name as Canvas. Majority of United States and Canadian students use this LMS for their students. So what I'd like you to do is consider the question now. If an AI system in your business failed tomorrow morning, producing a consensual error affecting to protect a population that you're serving, and you were required to brief your board within 45 minutes, what would you say? Could you answer the 4 questions that determine whether your briefing produces a governance decision or a governance deferral? Can those questions, are they going to fail? You as a speaker? Because the ideology behind here is who and what determines the effect, how severely was the population affected, what is the business or the organization's current regulatory exposure, transparency, responsibility, and accountability, and what specific action is being requested. Was it pre-planned, so you took proactivity, or you're just gonna decide at the time of the incident? Those are the questions this module teaches you to answer with precision, with evidence, and with authority that forensic documentation standards corner. And you don't necessarily need to have a PhD in order to obtain this lack of inability to not be able to speak, because I think if you are already in the world of business, your articulation, your ability to communicate effectively and understand the deliverables that is required in order for you to move forward with accountability when addressing a failure in an AI model. Now, the extant literature on AI governance implementation, including IAPP and FTI's Consulting AI Governance, in practice, Report 2024, the ISAC analysis of AI failures in 2025 discussed the convergence of finding that is both consistent and under theorized, and the majority of AI governance failures at the board level are not attributed to inadequate risk identification. They are attributed to inadequate risk communications. The analytical work was not done or completed properly according to the standard. The findings were accurate, but the communication failed. For structural failure, models account for the preponderance of the communication breakdowns. So failure model would be the jargon trap, and I talk about this quite a bit in most of my courses that I will be uploading in the near future. The jargon trap usually occurs when practitioners, administrators, operationals, CEOs deploy a technical, nomenclature, or regulatory terminologies without providing accessible definition scaffolding for non-special audiences. So meaning that someone may not be specialized in architectural, in computer science, or behavioral science, or forensic identification. The cognitive consequence is not confusion. It is a disengagement. Board members who encounter unexplained acronyms or regulatory citations do not ask clarifications because of their ego, right? They don't want to be embarrassed. They don't want to look like they don't know this information. They withdraw with epistemic investment from the briefing and redirect their attention to matters they can actually evaluate or understand. The governance recommendation fails not because the board disagrees with the decision, but because the board was unable to actually process it. So what this means is that in the source of AIG, the Artificial Governing Book, version 2.1, domain IB, practitioners and operationals must define and differentiate approaches to AI governance communication based on not just audiences' characteristics and capacity of knowledge. This must include for non-specialist stakeholders at the executive and board level. Problematic. If conformity assessment for, let's say, an Annex 3 system under the European Union AI Act has identified automation biases exposure in the mapping function outputs, creating a fundamental right impact assessment and the obligation have not yet operationalized. Therefore, it's imperative that we look at the proper revised form of assessment of the AI hiring tool, where you use to screen applicants that have found the system systemically at disadvantage certain candidate groups. So what we see is under the AI European law, which we don't see as much in the Western law, which applies to which applies to us because some of our application are under the European Union residence. We are legally required to document and address this. We have not yet done so. And this is the revised version where I want you to think about that every material element of finding eliminating every terminological barrier to board level comprehension. Again, the definition of precision is not sacrifice, it is translated that the translation is a professional obligation, not an act of simplification. Failure number 2, risk abstraction problem. AI risk, as currently communicated in most organizational governance briefings, is presented at a level of categorical abstraction that usually renders it not actionable. Most boards are informed that the organization may face reputational risk. Let me tell you, it's not may, it will. Regulatory risk or operational risk without specific mechanism, magnitude, or population or timeline that would enable the board to evaluate proportionately and properly allocate the resources or make the governance decision in a timely manner. The RMF AI NIST is precise on this point, and this is part of the reason I have used it over and over, because this is something that I use when I'm conducting my assessments, especially if I'm hired specifically for AI governance. And let me tell you, yesterday I had a possible bid, and I was sitting in this board panel, and I was talking away, and one of the younger recruits threw out a terminology that I have heard, but I have never utilized it because it's a language that I would not use, and it was called human loop. Now, I am aware of loops in AI, but I have never heard it referred to as human loop, and I thought, oh my god, I have no idea what this is. So I asked this young girl, and she was kind enough to explain it, but we call it the way I understood it was population sample loop. That's how I discuss it. But what I'm trying to show you is that simple jargon had put me in a place of conundrum, because I was like, am I able to even articulate what I'm saying? Like, I totally lost my footing. What I'm trying to say is that when you look at AI risk analysis to be employed in your organization, you must understand the measurement function that is required for that AI risk analysis. So whether it's quantitative, whether it's qualitative, whether it's mixed method tools to produce findings of sufficient or particular to support risk prioritization, and resources that may be required or already allocated. A risk that cannot be specified cannot be prioritized. Remember that. A risk that cannot be prioritized cannot be resourced. A risk that cannot be resourced cannot be governed. So what does that mean? In the RMF measurement function, quote unquote, employs quantitative, qualitative, or mixed method tools as a methodology to analyze, assess, benchmark, and monitor AI risks and responses, and measurement results inform risk prioritization. What would be problematic if the organization's current AI deployment posture creates significant regulatory exposure that requires urgent attention from the board, and you don't have it. So how do we do this? We revise it. If we deploy the applicant screening, for example, tool without a completed risk assessment, and for example, using the EU AI Act, deadline passes without our documentation in place, the maximum regulatory, and by the way, it's August 26, 2026. I've mentioned that in Module 1 and 2. The maximum regulatory fine is 70% of our global annual revenue. So for this organization, that is approximately, I don't know, let's say they would have a certain amount of numbers. The assessment we need to take is estimate 30 days and require no external less. So what this means is that the distinction between these formula is not theoretical, but the first produce of governance deferral is the second produce of the governance decision. So the quantification transforms an abstract obligation into a resource allocation problem that boards are equipped to resolve. Now, the failure model 3, this is where the accountability vacuum comes into effect, and I've talked about accountability like it's tattooed on my forehead in vacuuming communication. We have learned that it's very easy for individuals to simply pass the blame or accountability into somebody else. This is hence why the standard of forensic documentation is imperative, because you not only show the chain of command, but who handled what and in what capacity, who is responsible for and what capacity or caliber in this case. The accountability aspects when it comes to the board institutional decision making or the structure, they are constitutionally incapable of approving a recommendation that has a no name owner. So no name can be nobody's responsible for it, no specific deliverables, no defined timeline. So the governance briefing that concludes with exhortation to act without specific factors who act on someone's name and responsibility and what, by when, and what cost, with what measurable output, produces no governance action. So now not only are you putting yourself, your organization, your upper management, possibly frontline, and those all affected by it in a conundrum that you have to take responsibility for. That may cost the organization a substantial amount of fines, substantial amount of loss in revenue and profit. The accountability vacuum is communication directly extends the accountability vacuum in governance itself. So what we say is the body of knowledge domains that we have been talking about through the last 4 modules is required that governance responsibilities look at the defined and assigned, not aspirationally, but operationally. A governance recommendation that does not name a responsible actor is not a governance recommendation. It is an observation. So what this means is that if I were to use an example of accountability vacuum remediation is following this briefing. So I'm requesting a board approval for the compliance functions specifically for John Doe to lead a structured AI risk assessment of our 3 highest exposure systems. The deliverance is board ready forensic expert report that has to be produced within 30 days at an estimated internal cost of, so we're going to say $350 an hour for this particular officer. And the success criterion is a complete 7-element risk document review by an independent party submitted to the board no later than the end of the 30 days. So in this case, we'll say, what day is today? May 26, June 26, 2026. So every element of the request is evaluable and approved. The board knows who is responsible, what they will produce, what it will be delivered, what it will cost, and how successful will be assessed. Success must be assessed by a third party. So when you are dealing with a vendor who brings a third-party product to you, AI product, let's say, and you're like, okay, you know what, their reports line up, their numbers line up, it's cost effective, they have good reputable support and review. That's not sufficient. That is their people. You want to make something look really pretty, you can do so, and it's not that much trouble. So what makes it very imperative or important is the fact that you get a third-party assessor that is not related to the organization or to the vendor, and have them review those documentation. Why? Because that person has nothing to lose. It's a win-win for them. They get paid either way, and their findings is going to not only protect the organization but also be auditable to encourage the vendor to upgrade their system in areas or niches that needs to be upgraded. So every element of that request is now valuable, approvable, and the board knows everything they need to know about the operational specificity that governs communication that is required. The failure model 4 is the evidence gap. Boards test the credibility of governance recommendation by asking where the evidence originates from. Not only board, regulatory bodies, possible legal governing bodies. If you're within Ontario, you may have the ministry or the federal agencies seeking information. And why is all of this important? Because a governance professional who responds to the question with appeal to best practices or professional consequences or sector norms without citing variables, primary sources, where did you get this information from? Is it third party guaranteed? Is it, substantially proved? Is it academically tested, lab tested? Undermines the epistemic authority of the entire briefing. The board cannot evaluate what it cannot source. It's like saying the sky is blue. Well, how do you know the sky is blue? How did we learn the sky is blue? Well, because I looked up and the sky is blue, right? But that's not sufficient. That's not even admissible in court. That's based on your eyewitness testimony, right? The same thing is applicable when you submit evidentiary products, especially documents. The forensic epistemology of this course is predicted on the principle that every governance claim must be traceable to a verifiable evidentiary source. Think about it like this. If you cannot prove it, then it's not factual. It's not about who's done it. It's about showing how this person done it. It's about showing the steps this person took that was incomplete. A specific section of the NIST AR risk management framework is about a named article that is specific in the EU AI Act. Traceability is not academic formalism. It is the minimum evidentiary standard for communication that seeks to produce institutional actions. It would be problematic for you if your AI governance is increasing importance. An organization that fails to prioritize it face growing risk in evolutionary regulatory environment. Now, if you were to revise it, the United States of Government's primary AI governance standard that was published January of 2023 requires that organizations assign named accountability for AI incident responses prior to deployment, meaning Tiana MASH is responsible for the first deployment. We have deployed 3 AI systems. None of them have named incident owners. That is documented deficiency against AI adjustable standards. So for every AI product that you have to have a named person requesting or seeking information. Now, that formulation, named of the source, specific the requirements, identifies the deficiencies, and quantifies its scope. It can't not be dismissed as opinion. It can only be acted upon explicitly, accepted as a known risk, both which are governance and outcomes. I want you to pause and reflect on these questions. I want you to think about the last time you tried to communicate an AI governance concern to someone. I want you to think outside of the box. The post that you are doing, the fact that you're answering these questions is not about criticism. It's not about not knowing yourself. Please refrain from using AI answers. The reason I want you to challenge yourself is to really test your ability with your knowledge about AI. And you can either further your information. There's tons of courses on AI, different level governance. I teach it from a behavioral science perspective, and the engagement that is basically integrated between human interaction and machine. The community practitioners and administrators usually engage with this course represents a cross-sectional peer review mechanism. So I want your responses to tell me whether your communication achieves the clarity that the board level governance requires. And this is not to put anybody down. This is not to challenge anybody. And if you're not comfortable discussing it in the body of discussion posts, that's no problem at all. You can find me on LinkedIn under the same handle name as YouTube, and you can send me your questions there. I usually take about 24 to 48 hours to answer them, and if it's more detailed and I need to find some further research document or governing product or academic paperwork, it may take me up to 72 hours. All right, let's go to lesson 5.2, forensic reporting standards. I keep discussing this forensic reporting standards over and over. I do apologize. I'm not sure why my power presentation looks so convoluted, but I apologize for that. The lesson 5.2, this is the adjective forensics. This is the deployment through the course that carries a specific etymological weight. It denotes the application of the rigorous systemic evidence ground, that analytical methodology to really question that have consequential applications or legal matters, or legal ethical institutions or regulatory. A forensic report does not merely describe a situation, it establishes through documented evidence and structural reasoning, and a finding that can withstand adversarial examination by a regulatory body, a judicial proceeding, a board audit, or a professional peer review is imperative. The AI governance literature has not adequately theorized the communication dimension of governance documentation yet. The NIST AI RMF and the ISO IEC 42001 management system standards and the EU AI Act all mandate documentation, but to not what capacity. But their specification of what constitutes adequate documentation is primarily structural and not rhetorical. So this lesson addresses that gap by establishing the 5 principles that I think that you should use that will protect you not only as the accountable owner of a particular project or a particular briefing, the transform of structurally adequate documentation into what we call a communicative effective governance evidence. So when you look at principle 1 is primary of finding methodologies, so understanding forensic communication. So what does that essentially mean? Whether you're working in a forensic environment, in an institution, in a criminal investigation, or working as an AI governance auditor, you are structured so that the finding precedes the methodology. The conclusion is stated first. The evidentiary biases follow. The sequence is not stylic, it's preference, right? It is cognitive accommodation for not specialist decision-making audiences who must first understand what the finding is before they can evaluate whether the methodology that produced it is credible, viable, and authentic. So a board receiving an AI governance briefing that begins with a 20-minute exposition of assessment methodology before even arriving at the finding has experienced a sequential failures to overly maximize their cognitive overload, minimizing retention, and produces disengagement. And we see this even in students. They disengage, they get bored. And I always say to my students, I should be telling you all as well, these courses that I'm teaching, I've cut them down from sometimes 40 hours to 30 hours down to 1 hour to 1.5 hours to 2 hours. So don't take this course all in 1 hour. Give yourself a break, take those pauses, and actually answer these questions accordingly. Now, what does this essentially mean when we talk about lead with the finding? Lead with your conclusion, because you're allowing the person to hear what happened, how you found it, what was the results, and then you're going to go and explain step by step the methods that you took in order to come to the conclusion. So we're literally doing it backwards. Instead of providing intro, the bodies, the methodologies, the population, the research, and then the discussion. So you're doing it the opposite. To establish the communication that organizational need or expect for AI governance, you must include the capacity in which you deliver the structural awareness programming to all people, including stakeholder categories and AI strategists and governance implications. Principle 2 looks at the source of traceability of every evident claim. What does that essentially mean? Every claim in a governance briefing that asserts factual specificity, regulatory requirements, or risk magnitude, you're looking at the probability of assessment, a documented harm, and this must be traceable to verifiable primary sources. This is the audit trail requirement that AI Risk Management Framework describes under Governance and Manage section, because it functions as a systemic documentation that bolsters accountability and increases transparency. In practice, this means that before a governance briefing is delivered by you, every claim has been assigned a citation, every claim has been assigned maybe a page number, a date and time, and who authored it. The EU AI Act articles and the NIST function and subcategories and the IAPP AIGP body of knowledge domain, the peer review studies, they all talk about documented AI incidents. Without this preparation, the briefing is vulnerable to the evidential challenges that the boards consistently deploy against governance recommendations they are reluctant to fund. So for systemic documentation in RMF practices, you want to establish in governance and utilize in map and measure bolsters, and the AI risk management efforts and increased transparencies and accountabilities throughout the AI lifecycle. Point 3 is about quantifying the severity rating. The characterization of AI risk as a serious, significant, and elevated or urgent conveys no actionable information to really look at decision-making bodies. So the severity must be rated against to define scales with specific evidence base. They calibrated to the affected population and the magnitude of potential harm. These 3 tiers of severity framework is deployed in module 3 that I discussed, and it's derived from the NIST management function, and it talks about the requirements to be determined whether AI systems deployment should proceed or provide the operational instrument of this ratings. It's literally like, green, orange, red. The different tiers, the severity levels, whether it's going to be moderate, whether it's going to be severe, whether it's concerning. So a tier 1 finding, for example, requires monitoring and name review schedule. A tier 2 finding, for example, requires containment, name of the incident, ownership. So in this case, I say I am the person responsible for this incident, and the defined remediation timeline that I provided, and for every step that requires. Again, this was all discussed in Module 2 and Module 3. What this means is that the tier finding requires immediate system suspension. Bottom line, that's the red. So the executive notification, the regulatory notification, and full forensic documentation is required. So each tier carries defined governance obligations, and the severity of characterization that does not assign a tier produce no definition of obligation. So it produces a conversation. Now, it doesn't matter what tier it is, you're always going to have an ownership incident regardless. For the purpose, when I'm using a lot of these details from scientific paperwork or coursework, what I find is they say, well, tier 1. No, every tier must be taken seriously, and you must follow the proper containment. Now, it doesn't necessarily mean you need to shut down the AI system if you're in tier 1, but if you're in tier 2 and tier 3, there's a possibility that you have to do that. So this determination is made as to whether the AI system achieves its intended purpose and stated objectives, and whether it's deployable or deployment should proceed, and the reasoning for that determination is then documented. Principle 4, we look at the name and accountability in every recommendation. And what does that mean? This is governance recommendation that assigns responsibility to organizational functions. So team or unexpected leadership categories produce non-governance accountability. So the IAPP or body of knowledge talks about explicit governance professionalism that have to be defined in roles and responsibilities of AI governance stakeholders. Now, The definition, again, may not be specific to an individual or specific categories, but I want you to realize that the recommendations are unavailable and unapproval if you don't have all of the necessary bodies for accountability when you're delivering this project. And principle 5, we talk about pre-specific next action. And what that is the terminal failure mode of governance briefing is the conclusion that calls for continued discussion. And I find further analysis or ongoing attention is required. None of these formulation produce governance actions. The forensic standard required that every governance communication concludes with a signal, pre-specific next pro-action. So instead of just predicting, come up with a next action. You are able to pre-predict a possibility. Is it going to happen? No one really knows, but you're taking that essential step in order to get that done. The actionable by receiving body within a defined time frame. Again, with a named owner, the receiving person's decision is binary. So if I approve something, then it's going to be approved explicitly or explicitly decline. Both are governance outcomes. This is a continued discussion, right? Continued discussion is not just about approving something and not approving something. Everything that one does in an AI governance team needs to be justified, needs to be actionable, needs to be explicit, it needs to be in detail. You need to have not only conformity, but you need to also have substantiation, proof, and evidentiary work in order to challenge people that may have questions or concerns, especially when it comes to regulatory bodies. Now, the analysis for EU digital ombudsman is the backstop compliance dates that are applicable irrespective of compliance support availability. So now I believe the EU came up with it they are being established 2027, possibly around December, for high-risk AI system under Annex 3, and August 2nd, I think, 2028 for the under Annex. So they have two different set dates that have to come up that EU Digital Ombudsman has been working on. Now let's go to slide number 7. Again, this is a question for you. The second question produces a real governance work. So screenshot it, retain it. It belongs to section 3 of the template. You will complete lesson in 5.6, or you can just simply download the power presentation that I will be providing for you, because the power presentations are all being provided for your view. So that's that. Let's go to slide number 8. Pervasive risk briefings. This is where we talk about the AIARE framework. The Ontario Public Service Behavioural Competency Dictionary that was served, I think, in 2015, defined the impact and influence as the ability to influence or persuade or convince others to adopt a specific mindset or course of action through the use of persuasive techniques. And presentations or negotiation skills are designed to gain that support, that agreement or commitment. At its third proficiency level, the competency requires that the practitioner adapts a presentation that is delivery to the audience level and interest, so therefore making it multiple distinctive argument to persuade or anticipate the effect of an ongoing action to prepare, like stakeholder reactions. So especially for these kinds of concepts, in the context of AI governance communication, the competency is not aspirational. In the IAPP AIGP body of knowledge domain, we look at mandates that capacity to establish external communication plans as a governance obligation, and the ability to persuade a board to authorize a governance program is the mechanism through which the mandate is fulfilled. If you cannot move your board from awareness to action, your governance function is analytically complete and institutionally inoperative. So you have the paperwork, and this is where we find a lot of institutions are falling behind. They have the paperwork, but it's not operative. And what does that mean? Because when you're looking at impact and influence, you're looking at adapt, adjust, presentation delivery, or discussion to appeal to the interest level of the audiences as required. So make two or more different arguments to persuade anticipation, the effect and action of prepared for other actions. The AIARE framework provides a structural 5-move architectural for constructing a persuasive AI governance briefing, and each move is grounded, but in concept of behavioral science and organizational psychology for sure. So what I'm saying is move in anchor. So anchor is the first one. Anchor move opens the briefing with a document instance of AI failure in the same sector as receiving the organization or a case that is drawn from an AI incident database. From regulatory enforcement records, or let's say from peer review incident analysis. So there's a combination of where you can get this case from. The behavioral science base for this move is loss aversion. The documented cognitive symmetry identified by Kahneman and Tversky in their foundational work on prospect theory, where they discuss the effect of weight of potential loss substantially exceeds the effect of weight of equivalent potential gain. So what this means is that a board that is shown what happens to an organization similar to them that failed its governance AI system is engaging with concrete precedents, not abstract risk. So basically showing them where they could go wrong if they don't have something in place. The AI incident database at incidentabase as .ai maintains over 700 documented AI failure cases. It's called incidentdatabase.ai. You can look it up on your own convenient time. And the categories are by sector, so harm type, organizational response. This is your primary evidentiary resources for anchor move. Use it before every board briefing. The case you need is almost certainly going to be there. Now, what does this actually mean under MIT at-risk repository? The repository synthesizes that 95% peer-reviewed studies and documentation over 1,700 coded AI risk across organizations, societal and technical domains, providing the evidentiary base for sector-specific risk precedents in the governance communication. Number 2 is going to be the impact. The impact move translates AI risk into financial, legal, and reputational terms that continues the primary evaluation framework board at a level of decision making. So the abstract risk is not actionable. It quantifies the consequences, is evaluable, and with the EU AI Act, penalty architectural I'm having so much difficulty speaking English today. Maximize fines of 7 precedent global annual revenues in order to find serious violations under the Article 99 that was discussed in Module 1. Now, provide a concrete financial reference point that every board can calculate against their own revenue figures. So the calculation is not an intimidation and it's not a threat. It is proportionate analysis, the same analytical mode that the boards apply to every resource allocation decision. The governance investment you are requesting should be present against the regulatory exposure it addresses. If the investment is proportionately rational, the quantification strength of the case would be higher. If the board declines the investment quantification, ensures that the regulatory exposure has been formally communicated and cannot subsequently be characterized as having been unknown to the board. So you are covering yourself, or CYA. You can put whatever terminologies you want to put in there after. A for ask. The ask move states specific requests before the analytical exposition. The sequencing in counterintuitive to governance practitioners trained in academic or technical framework, where methodology conventionally precedes conclusion. So in a board communication context, however, a front-loading that request has 2 critical functions. One, it establishes a decision frame before the evidence is even presented. And second, it enables the board members to really organize their evaluation based on the evidence against the defined decision rather than proceeding it without references or its purpose. And therefore, this prevents the cognitive phenomena of analysis paralysis that we discussed in Module 2, the tendency to defer action when the relationship between evidence and required response is not made explicitly until the end of the complex presentation. So the ask must be specific: a name actor or a governing body or an officer, a defined deliverable, a timeline, a cost that is estimated, and a success criterion that is required to get you from destination A to destination Z. Everything in this module has been built towards a moment where the board can say yes or no. The ask is that moment. Moving from ask to reassurance. The reassurance move acknowledges and explicitly affirms the governance control currently in place before presenting the governance gaps that they do not address. The sequential is critical because boards that experience governance briefing as critiques of their oversight failure usually respond defensively rather than analytically. So this is something you can actually say at the beginning. This is not to critique people's roles. This is analytically to discuss what has happened, what the decision's outcome were. The reassurance move prevents that response by demonstrating the present has complete and accurate picture of the organization's current governance posture, including its strengths, rather than a selective negative account designed to justify a resource request. The behavioral science basis for this move is the same as the principle that informs motivational interviewing in clinical practices: acknowledgement of the existing capacity resources, psychological reactance, and increased receptivity to change-oriented information. Apply to board communication. This means show them what they have done correctly before showing them what they have not done yet. So start with positive, go into negative, start with positive, provide an explanation that is positive, and then debrief them on the areas that needs improvement. Number 5 is the escalation. The escalation move closes the briefing with the specific time-bound source consequential of inaction. The consequences is if you don't do it, these are the results. Not the general risk of non-compliance, but be specific about the regulatory deadline, specific about penalty mechanism, be specific about enforcement authority, and the specific timeline which the consequences will materialize if the request action is not taken. Companies hear about money. Am I going to lose money? Am I going to lose money? Am I going to lose money? Number 2 is, are we going to lose our reputation? If we lose our reputation, is this going to attach our stakeholders, right? Is this going to attack us in any other capacity? So they start to think money, money, money. For Annex 3rd high-risk AI systems that comes out December 2nd, 2027 this year, for Annex 1 high-risk system, August 2nd, 2028, these are not proposed targets. They are statutory backstops and operative irrespective of whether technical standards or compliance guidance have been finalized. The escalated move names these dates and connects them to specific systems in the briefing and specific to the regulatory notifications or obligations that are not compliant. So let me give you an example of something that transpired with a company and how they approached it. So we're talking about Anchor here. Anchor first. In March 2025, a financial service organization in the EU was fined, I won't say the amount, after its AI credit scoring system was found to have systemically disadvantaged applicants from protected demographic groups. So for the 14 months of the case that was documented, the AI incident in a database. So what they did was it was based on gender, based on race, it was based on postal code, so lower socioeconomical housings, and what they found was the impact. The impact was that their own credit scoring system operated on a similar architecture. Can you believe that? On a similar architecture system of the AI. So if a comparable findings were made against them, the maximum EU AI Act penalty would be calculated at a much higher number. So the impact, I think, is at 75%. So the impact I'm requesting would be, for example, if I were there, I would be like, okay, so I'm requesting board authorization today for a structured risk assessment for our 3 highest exposure AI systems. This would be to lead by, you would name an officer, Jane Doe, delivered in 30 days at an establishment or estimated cost of, let's say, $250,000. Reassurance: your data and governance protocols and vendor contracts are current and compliant with PPDIA, and the gap is not in our data management, it is in our AI-specific risk assessment documented. Now you're going to escalate it. So what are you going to do? If we do not complete the assessment and establish document risk management procedures before December 2nd, 2027, we will be in the violation of EU AI Act requirements that is applicable to our Annex 3 system, which regulatory notification obligations that will become a public record. So what this means is that because AI is now globally marketed and it connects people globally, we as AI governance bodies have to make sure that we are meeting all the requirements according to what is provided. So South Korea's, China's, European Union, and of course Canada and US, right? This is part of it. And if you think, well, that's too much to read, well, lucky for you, reading advances your knowledge. And here are different, again, I want you to look at these questions and think about it in a leadership perspective. Now, when you say all levels and you see leadership, the reason I have all levels is because sometimes people are starting this course, and when I speak, and I do have a slight accent periodically, certain words don't come out properly. My apologies for that. But what you will find is you may not be as advanced in certain areas, and that is okay because practice makes perfect. As long as you have a basic knowledge of research methods, I use APA referencing, so you're able to reference your products and how you include in-text citations. This is what's imperative. For those of you that are in the leadership roles and need further acknowledgement or further clarification, you can always scroll down to the last slide, and I have resources and references there that you can utilize accordingly. Regulatory versus organizational language. The architecture of regulatory to organizational translation, the regulatory ecosystem for governing AI development has undergone a substantial dynamic elaborative across, I think, multiple jurisdictions since 2023. The one that we use the most is the EU AI Act that entered into the force on August 2024, and the NIST AI Risk Management Framework 1.0 was published in January of 2023, with an expanded companion playbook issued through 2024 and 2025. So the EU Digital Omnibus proposal in December of 2025 restructures the multiple compliance obligation, and the IAPP AIG Body of Knowledge version 2.1 that was published in 2026 maps the competency domains against which AI governance professionals are now evaluating internationally. So the ISO IEC 42001 AI management system standards that are established, the first internationally recognized audit framework for AI governance programs. If you're wondering what all these names and numbers are, if you just copy and paste what is provided for you on the slide presentation right here, you can actually get all of these downloadable. You can actually download them and retrieve them, actual copies. Some of them are like 100 pages, some of them are like 60 pages. So you can create an external hard drive or on your PC, have a portfolio or a file, and you can put all of these there, especially if you're planning to use them for your own purpose, or even if you're making a simple documentation. It actually is great to have that as well. Now, the practitioners or administrators who have mastered this regulatory architectural usually face a specific professional challenge: the vocabulary of that mastery. The acronyms, the article referencing, the framework nomenclature is systemically inaccessible to the board level and execution audiences whose decisions determine whether governance programs are funded and implemented. Meaning, just because you speak at a higher level and your intelligence in the frame of scholastic experience is at a higher level, it doesn't necessarily mean that your board members are going to be at the same capacity of understanding and intelligence when it comes to that specific knowledge. The professional translation of regulatory precision into organizational intelligibility without actually losing the definition or sacrificing the definition accuracy is a core professional competency. No one's going to think that you're less if you're not using big vocabularies. What people want to know is what am I reading, right? What am I reading? That is the bottom line. Because if someone doesn't understand something, they're going to make it up in their own head based on their own experience and lived in experience and their own experiences on the job and interpretation of what they have witnessed. The translation table is the lesson provided for operational translations for the 6 of the most governance critical regulatory terms. I'm going to work through each one with few analytical framing that makes it translatable or translationable, but it doesn't necessarily mean you have to use this as your specifics. A conformity assessment is a procedural mechanism through which a provider of high risk assessment demonstrates through documentation evidence that the system meets the technical transparency, the human oversight, and risk management requirements specific for the EU AI Act. For board communication purposes, the translations are as followed: a pre-deployment review that produces documents based on evidence that our AI systems meet legally mandated standards before it goes live. The critical element for the board comprehension is a sequencing implementation. So conformity assessment is a pre-deployment obligation, not a post-deployment remediation. If the system is already deployed, the conformity assessment is retroactive and the organization may already be in violation. Term 2 is fundamental human rights and how it's affected. When we are talking about the fundamental of human rights, the FRIA is a mandatory assessment, not an elective best practice required under any of these articles or regulatory governing bodies for publication authorities, and it regulates entities to deploy high-risk AI system listed in Annex 3. It systemically evaluates the system impact on the fundamental rights of enumerated in the EU Charter: human dignity, privacy, non-discrimination, democratic participation, and access to justice. For board communication, a rights impact review that documents whether and how this AI system is affected to legal rights of the people is processed data about and what we have done to address those impacts. So the FRIA intersects directly with the GDPR, the EU Digital Ombuds proposed standardization of the fundamental rights impact assessment methodology through, and the EDB guidances, which will increase the auditory visibly for non-compliance. And then we look at the NIST arm right here. The manage or the function of the 4th of 4 core functions of the NIST Risk Management Assessment Framework. I have discussed these over and over in every module. And the reason for that is because when you address how organizations allocate resources to address specific identified risks, and how they choose to establish a response protocol and what steps they implement for ongoing monitoring and improving their mechanisms. For board communication, you use a more simpler language: our AI incident response and risk treatment plan. The documentation has procedures that specify what we do when an AI system fails a procedural harm or output, who's responsible, and how do we communicate with effective parties and regulatories. The absence of manage function implementation is the single most common AI governance deficiency identified in the analysis AI failure by ISAC in 2025. What this means is that the purpose, risk treatment, compromises plans to respond accordingly or recover from or communicate about incidents or events to many governing bodies, but also frontline personnel and people that are affected or population that is affected. So processing for assessing emergency risk are in place along the mechanism for continued improvement. Term 4, pro-marketing monitor. This falls under the EU AI Act Article 72. Post-market monitoring is the continuous performance of surveillance obligations that applies to high-risk systems, and this is right after deployment. It requires providers to be proactive and collect and analyze data ongoing during, and thereafter, and the system performances. You have to identify systemic failures or drifts from expected outputs, and then report serious incidents to the national competent authorities without any delay. The EU Digital Ombuds, the purpose in December 2025 that it came out was to remove the requirements for providers to follow a commission prescribed monitoring template, but the monitoring obligation itself, it still remains. For board communication, you want to say something like ongoing performance tracking that ensures the AI system contributes to functions as intended after launch and that any failure is detected. So documented and reported to regulators with the requirement time frame. Now, number 5 is legitimate interest biases for AI training. The EU Digital Ombuds usually proposes the clarity to process personal data. For the development and operation of AI models may be carried out under the legitimate interest and legal basis. So the subject to a balancing test demonstrates necessities, proportionate and appropriate safeguard. The proposal reflects the December 2024 governing document that came out about opinions on AI models organization and interest that is not overwritten by the data subject interest. But the idea here is how the variable legal basis and circumstances were actually processed within the organization. So for the purpose of working with your company, you want to use terminologies that make sense. So we provide and can provide documents that our organizational interest is doing well or outweighs the privacy interest, or the individual whose data we are using. The documentation provides burden is significant and non-trivial. Okay, so again, you have this choice of looking at the questions that if you want to answer against it's all levels and then advanced. As you know, I'm not going to repeat myself. I like to read them, provide them. If you are in the process of creating a portfolio for your AI governance and need my assistance, I'd be more than happy to provide that for you. If you usually comment something, then I know that you've reviewed the module, and what I will do is I will then respond to your email. So if you just put nothing and request an email, I will not respond. Fair is fair. All right, presenting under pressure. This is an area where most people cave, right? So there's 5 points in maintaining analytical authority, evidentiary precision when presenting under institutional pressure. For competency, behavioral competency under the self-awareness section, we talk about 3rd proficiency level. It requires that the practitioner remains grounded and not allow others' emotions or opinions to derail them, while simultaneously trying to recognize the impact that their own emotional response is having on this dynamic of interactions. In a boardroom context where AI governance recommendations face institutional resistance, financial scrutiny, or political skepticism, this competency is not supplementary. It is the cognitive foundation of effective governance communication. So do not make a reaction based on a temporary emotional break or emotional deviation. The 6 challenge archetypes account for the preponderance of the boardroom assistance to AI governance investment. Each requires a distinctive analytical response. So not a defensive response, not an empathetic response, but a response that is grounded in evidence and structure to redirect the board's analytical engagement towards the governance question rather than the governance discomfort. So what we're trying to say is that you are trying to remain grounded, and it does not allow other people to kind of cite you up, entice you up, instigate you. So your opinions stay and maintain where they are. You have to recognize the impact that your emotions may have, not only on the people that are observing you, but also on your performance, on your team, and your decision-making dynamics. It's all about who you are, and in situations that you feel that you are losing that sense of grounding, then you need to step back, take a couple deep breaths. If people say count to 10, I say take 3 deep breaths, don't look at anybody, stare at the wall, and then restart. Archetype challenge number one was legal coverage as governance adequacy. The board asserts that legal reviews has already been completed, let's say, and the organization is covered. The challenges conflate legal compliance. So the minimum threshold requires for you to avoid regulatory sanction, which governance adequacy, the standard required to prevent harm or manage risk or maintain institutional integrity. So when you're talking about legal coverage and governance adequacy, you have to think about it analytically. A distinct and practicality that is separable. An organization can be legally compliant under current regulatory interpretations while being profoundly exposed to harm mechanism, operational disruption, and reputational consequences that AI governance failures produce. The appropriate analytical response is to explicitly articulate the distinction without challenging the legal team's compliance. So the legal review establishes our minimum compliance, the threshold governance establishes our risk, and then you talk about the manageable standards. So the gaps between these two are standard and is precise legally. And then we are going to talk about historical incidents and absence risk management. You might think, why do we even care, right? Why does that even matter? The board usually will argue that there's years of AI deployment without any significant incidents that constituted evidence or adequate in governance in their organization. This argument reflects a fundamental misunderstanding, misguided of a probabilistic risk, specifically the confusion between the base rate of observable adverse events and the underlying risk profile of a system that has not yet been formally assessed. The NIST AI risk process management framework explicitly addresses this risk. So you can say risk management is not a response to observe failure, but to be a proactive person processing or identifying and addressing these potential failures modes before they materialize. And this is a thing, we're predicting what could possibly happen in the future. The analytical response usually would be something like historical absence of incidents is not evidence in the governance adequacy program file that we currently have. What it is evidence of luck and low probability denominator, so we've been lucky. But the risk repository document over 1,700 AI risk categories, the absence of an observable incident means we have not yet been exposed to specific conditions that trigger the risks our systems carry. So their obligation is to identify those risks before the conditions actually arise, not after they have. And again, we talked about the learning management system recently, Canvas infrastructure, that was hacked, and over, I believe, don't quote me, over about 1 million students were affected by it, where their information was all leaked. Return to investment demand. The board demands a qualified, usually we say a qualified representative to work on specific factors, right? What does that essentially have anything to do with when you're talking about demand and investment? It comes down to dollars and change, right? What it means is that the challenge is legitimate and analytically traceable, but only if the officers or practitioners or leaders have prepared the numerical input. The ROI framework for an AI governance investment is straightforward. The denominators is the cost of the governance program. The numerators is the expected value of risk avoidance. So calculate at the product of the probability of adverse outcome and the magnitude of potential loss. For high-risk AI systems in scope of EU AI Act, the maximum penalty under Article 99 is 7% of global annual revenue. Do you know how high that is? For an organization generating $500 million annually, that is $35 million. If the probability of a serious incident over a 5-year horizon is estimated for AI risk repository frequency data or for similar systems is 10%. So the expected value of the risk is $3.5 million. If the governance program costs $150,000, the risk adjusted ROI is 23-1. That is the formulation the board needs. Prepare it before the meeting. Put them in number, because when they think they're losing money, that's when things become real. Compensation requests or simplifications. A board member may state something like they do not understand the framework being presented at the requested simplification. This challenge is not obstacle, it is an invitation. So it signals that the board member is engaged and is seeking understanding rather than deflecting. So don't take it personal, change the narrative. The appropriate response would be is this application of principle from lesson 5.2, that we will say the findings in 2 sentences without technical numerical clause, then offer the answer question about the evidentiary basis. Of course, here is the plain language version. Everything else is presented is a document evidentiary support system, that conclusion. So you can go back and use any of the form of the articles or the frameworks that we've already discussed and give them set dates. A lot of people become confrontational or they present an angry face when they don't know what's going on. And especially at a higher level of status, everybody likes to pretend they know it all. We don't. You know how many times my students teach me in class? This is why it's imperative that even you yourself that is listening to this lecture, you're willing to say, hey, you were incorrect in this, put it out there. Call me out. This is how we correct incorrect information or facts that are inaccurate. There's nothing wrong. When you are conducting research, you're also could be biased. You're interpreting it in your own language, in your own understanding, in your own comprehension level of that particular topic. So therefore, there's nothing wrong. Why lead on compliance? Another reason you want to lead on your compliance, because if your team or committee questions why the organization should invest in governance infrastructure when competitors have not done it yet, this challenge is again misunderstanding the liability architecture of AI governance. Governance deficiencies are not competitive disadvantages in short term. They are a liability accumulation that crystallizes catastrophic into a point in adverse events and regulatory audits. Regardless of what competitors have done, the anchor move in the AIARE framework is the instrument for this response. Here's what happens to blah, blah, blah when they did not blah, blah, blah. The fact that their competitors also did not govern adequately does not appear in the regulatory sanctions, only they do. So you need to actually articulate what happened to the competitors that we think nothing happened to them. But in respect, when something does happen, how often do you hear companies being transparent? They always want to keep everything, under the covers. Nobody should be discussing it. Don't acknowledge it. Now, framing attributions. The board characterizes usually the governance briefing as alarming or disproportionately risk focused, meaning that we overemphasize at governance experts. The challenge is the most direct attack on any practitioner's epistemic authority, and it requires more analytical grounding and response. So the response is not defensive again and not empathetic. You have to base it on evidentiary finding. Every quantitative claim in this briefing cites a specific primary source. Blah blah. So for example, you will say NIST AR, AI risk management framework, European United AI Act, or document incident of the AI incident database. I am not characterizing risk, I am reporting it. If any specific claims in this briefing is inaccurate, I would ask that, for example, the committee identify it and I will correct it on record. If no claim is inaccurate, I would specifically note that the appropriate response to accurate risk information is governance action, not reclassification of the information. So you have to stand your groundwork and you have to understand where you're essentially where you're going with this and how you're viewing things and what you're looking at. It is not about covering, it's not about opting out system without probe, it's understanding the chances that you are taking as an individual and how you're approaching it. Again, you have a couple questions that I'd like you to look at and answer. I'm going to try to speed this up a bit because we only have 17 slides, but I tend to over-educate sometimes and it backfires on me. So lesson 5, your complete board briefing template. The 7-section structure I'm going to walk you through is not just a communication convention, but it is the Integration of the module of governance methodology into a single document architecture. That means 3 simultaneously standard, the forensic evidentiary standard from a clinical and legal perspective, the documentation requirements of NIST AR risk management framework that governs, map, measures, and manages, and the function and the regulatory transparency obligation of the EU AI Act and IAGP body of knowledge. So what I want you to look at when you're looking at these different standards that we are looking at is understand what each rule is. Executive summary again states the finding in 2 sentences, and you want to find recommendation in 1. It applies principle of one of the forensic reporting standards, conclusion before methodology, always remember that, and ask move of the AIARE framework simultaneously. The finding names of the system, the risk tiers, and the affected population. And then we're going to discuss the recommendation names of the actors, deliverables, and timelines. Nothing else belongs in the executive summary. Everything else belongs in the section that follows after. The AI system under assessment. This section constitutes a scoping documentation that requires AR mapping functions, and specifically map 1.1 subcategory requiring for you to intend your purpose, deployment contacts, user type, and affected population be understood and documented. This has to contain the system identifiers, the vendor and procurement contacts, the intent, use case, and actual operation use of scope. Drift has occurred. Why? The population whose data is processed or whose outcome the system affected, the data of deployment, and the name of the owner of the system in the governance obligation. The distinction between intended use and actual operational use is critical. The scope drift failure category from Module 3, one of the 5 highest probability of AI failure patterns is identified as AI risk repository because it manifests precisely in the gap between what system was procured to do and what it has subsequently been deployed to do. It's the gap is in your organization. So section 2, where it becomes visible in the governance record. Risk assessment findings should be articulated very distinctively, explicitly. In this section, the documentation has to have outputs that structure risk assessment methodology and module 2. The biopsychosocial assessment across the 3 dimensions, so technical, architectural, human system interaction dynamics, and societal organizational impact. This produces evidentiary foundation for the risk classification. The failure of the 5 categories, so data governance failure, human oversight gap, scope drift, accountability vacuum, and transparency deficiency, are assessed for each system. A severity tier is assigned under 3-tier framework where we discussed it from module 3. The evidence base for tier assignments is cited. You cite it in your assessment finding. This section is where analytical rigor for module 2 and 3 becomes communication legable to board. Now, they may not understand legal liability or legal communication, but it has to be legible. Remember, you have to use simple language for them to understand. The committee does not need to understand biopsychosocial framework to evaluate its output. They need to understand the finding, the tier, and the evidence. The rest of that stuff is yours. The regulatory obligations. The regulatory obligation focuses on section translates the regulatory architectural that is identified in lesson 5.4 in this module specific, and enumerates the list of legal obligations that has to be applied to the system under the assessment. So each obligation is cited by its source of instrument, and again, you can use EU articles, NIST function, PIPE ADA, and sector-specific law. You can look at characterization in board accessible language using, again, translation framework from lesson 5.4. You can use a lot of different language. The section is what allows the board to understand the legal context of the governance request. Now, usually in a governance team, there's always a legal body that is there. So a counsel, a paralegal, someone who is, their foundation is bounded by judicial system and understanding. And then you have current controls. What does that mean? Current controls focuses on reassurance moving of the AIARE framework at the document level. It catalogs the governance control, current operational movements, data governance protocols, vendor contractual provisions, privacies, impact statements, existing monitoring mechanisms. So before presenting the control gap that the assessment has identified, this is a sequencing and analytical, honest, and psychological strategic approach. Your committee receives an accurate picture of the organization's current governance posture before being presented with the gaps in the posture. These prevent the defensive responses that briefing structures usually provide and focus on the indictments and the inconsistency that it has produced. Section 6, recommended actions. If you see it right here, so this section contains the fully specific governance recommendation. The name of the actors involved, the specific deliverables provided, the timeline, the estimated cost, and the success criterion. It is the operationalized principle that needs to be used, and there's 4 principles, and I think, principle 4 and principle 5 of the forensic reporting standard simultaneously. Noting that in this section, you cannot be vague. You have to be qualified, and you have to make sure that you're providing information where they are understanding. So every element is evaluated and approved. The committee's decision is binary. That clarity is intentional. And of course, we look at section 7, the consequences of inaction. This section is applied the escalation subcategory. Move of AIARE Framework at the documentation level. It specifies in 1 paragraph the regulatory consequences of the committee not approving. Here's the specific legal obligations, the compliance deadlines, the maximum penalties the organization can face, or the person in charge, the enforcement authority, the nature of the notification obligation that might trigger serious incidents in the absence of proposed governance control. It is not a prediction. It is a statutory analysis, and every claim it contains is cited. When the board reviews this, even with their lack of ability to maybe understand the 7-section forensic documents, they are not receiving a governance recommendation. They are receiving a governance decision. Already structured, already evident, already specified its requirement and its interaction consequences. The role is not approved, modified, or explicitly declined. All 3 are legitimate governance outcomes. The absence of the decision is not. Again, here's a question for you to reflect on. Now, retain the sentences, I want you to think about it in an analytical starting point for Module 6, because building defensible AI governance protocols, the capstone of this course were the communicative competencies of Module 5 and the analytical methodologies of Module 2 through 4 converge in a single jurisdiction-specific government document, right? So the empirical regulation founding that you have seen before you for module draws from the primary sources that are available. Again, if you watch these presentations and you know what slide they are, the time, and you put that in the body, or if you send me a LinkedIn message via email, I will respond accordingly. I'm even more than comfortable reviewing your paperwork if you have anything. All references are enumerated on the slide, so you know who's what, who says what, so all the documentation is available for you. And again, you can also find a lot of these information in their respective websites. If you go and actually find it, you will find it in that area. So this takes us to the end of our presentation, and I appreciate you coming. 6 lessons, 6 instruments, a diagnostic taxonomy of communication failure models. We discussed the 5 principles of forensic reporting standards, the AIARE Persuasion Framework, a regulatory transition architectural scripted response and repertoire for the board resistance, and 7 section on board briefing templates that integrate everything in the course has been built in this module single, like defensible immediate deployment. Module 6 is the capstone. It is called Building Defensible AI Governance Protocol. It synthesizes the risk assessment methodology of Module 2, the LAP-C incident responses framework in Module 3, and the human behavior governance content for Module 4, and the communication architecture of this module into a complete jurisdiction that you can use in a protocol document. So before you go, I just want to let you know that the statement about this channel is is and what cost. This course is free. It will remain free. Every module, every framework, every analytical tool, every template accessible to any practitioner, any sector, regardless of organizational budget or institutional affiliation. This is a deliberate commitment, equitable access to professional knowledge, grounded in the same principle of contestability and transparency that this course applies for AI governance. This channel is part of a long-term project for me, the construct of a free, comprehensive, evidence-based AI governance curriculum, that is accessible to practitioners every career stage, in every jurisdiction and every sector. Your follow and your share are the sustainability of this infrastructure for the project. So I thank you again. Come back, post what you produce, and I will see you in Module 6. See you later, everyone.